All right. Hi, good morning, ladies and gentlemen, and a warm welcome to today's webinar on using international court systems as a legal pathway towards climate justice in Africa. My name is Nomasango Masiamoyo, and I am the coordinator of the Environmental Lawyers Collective for Africa. Joining me as your co-host today is Nicole Loza, an esteemed environmental justice lawyer and consultant here at Natural Justice. Together, Nicole and I will be taking you through this important discussion, which is but one of 5 other sessions running for 12 hours globally. The sessions form part of a collective conference by partner organizations who recognize the ongoing efforts to obtain advisory opinions before the ICJ, which is the International Court of Justice, the Inter-American Court of Human Rights, and the International Tribunal for the Law of the Sea. In light of these international court processes on climate change, today's webinar will delve into a critical topic at the intersection of law, climate change, and justice. As we know, climate change poses existential threats globally, but its impacts are disproportionately felt in Africa, where vulnerable communities face profound challenges from droughts, floods, and other climate-related disasters. Addressing these challenges requires innovative approaches, including leveraging international legal frameworks and court systems. Throughout our session, we will explore how international court systems can serve as viable pathways for achieving climate justice in Africa. From holding governments and corporations accountable for environmental degradation to advocating for the rights of affected communities, the legal avenues available play a pivotal role in shaping sustainable and equitable outcomes. I encourage each of you to actively participate in today's discussion. Your questions, insights, and perspectives are really invaluable in enriching our dialogue and exploring these nuances of this complex issue. So just to give you a brief overview of how our program will unfold, we're going to open up with a keynote address from a distinguished speaker. After this, our panelists are going to address specific aspects of using international court systems in Africa, responding basically to individual questions that are tailored to their expertise. After these presentations, we'll give you all an opportunity to field some questions to our panelists, and you'll get the opportunity to engage directly with them. Thank you once again for joining us, and let's begin our journey towards a more just and sustainable future. Over to you, Nicole.
All right. Hi, everybody. Norma, my name is Nicole Loza, and also just from me, a very big thank you to our panelists who have joined from all over the world today, and for giving your time to be with us today. It's really appreciated, and we really look forward to hearing your insights. So I'm going to be introducing Rosaline to do our keynote to get us kicked off. So Rosaline Oguche is a human rights lawyer and climate change activist. She's a campaigner from Nigeria, and she is the deputy coordinator of the African Front of the World's Youth for Climate Justice. Rosaline previously served as a programs officer and team lead at the African Blue Economy Alliance, which is an NGO dedicated to advancing the climate action agenda through tailor-made ocean literacy projects and initiatives centered on the blue economy and how it can be harnessed to cater to the global climate crisis. Rosaline loves writing and engaging in community outreaches. So over to you. Thank you, Rosaline, for the keynote introduction.
Thank you so much. Good morning, afternoon, or evening to everyone joining from around the world. I am delighted to welcome you to this webinar titled Navigating the Climate Emergency and the Role of International Courts and Advisory Opinions. Together today, we will explore an intersection of climate action and international law and the immense promise that it holds for our collective future. The climate crisis is undeniably the most pressing challenge of our time. Its impacts are far-reaching, affecting every corner of the globe, And I can say that it has disproportionately impacted the most vulnerable populations, particularly developing regions such as Africa. The urgency of this situation demands robust and innovative approaches to governance, accountability, and justice. It is within the context of this that international courts and their advisory opinion becomes profoundly significant. As many of you already know, the International Court of Justice has been approached to provide an advisory opinion on the responsibilities of states under international law. Give me a minute. I beg your pardon. On the responsibilities of states under international law to protect climate change. These requests were spearheaded by enthusiastic youths like you and I. And though the advisory opinion, non-binding, holds the potential to clarify the legal obligations, which should inspire stronger national policies and foster greater international cooperation. Today, this webinar is inspired by the remarkable campaign, I beg your pardon, led by the World Youth for Climate Justice. This movement, which was fueled by passionate and innovative, young-spirited individuals worldwide, has been instrumental in bringing the advisory opinion discourse to the global front. This campaign underscores a vital truth, which is that the voices of youths are not just important, they are indispensable in this matter. In Africa, where a significant portion of the population is young, the leadership and activism of youth in climate movement have been particularly impactful, as we can all agree that the youth are not just the leaders of tomorrow, but the change makers of today. Today, we will look into the mechanisms and implications of the advisory opinion from the International Court of Justice. We will examine how we can leverage on this advisory opinion to enhance the climate action globally. We will also hear from distinguished speakers and panelists who will provide us diverse perspectives on the potential impacts and perhaps the challenges of using this legal route. As we embark on this discussion, let us remember that the climate emergency is not just an environmental issue, it is a matter of justice, human rights, and intergenerational equity. The role of international courts and advisory opinion will show us the power of law in shaping the response to this climate crisis. It is a reminder, though, that while we face unprecedented challenges, we also have the same opportunities to make meaningful change. Thank you for joining us in this important conversation. Together, let us explore, learn, and be inspired to act with greater urgency and resolve. The future of our planet depends on it. Welcome to this webinar, and thank you all.
Thank you, Rosaline, for that introduction. Much appreciated. All right, so we're now going to kick off. We wanted to keep things relatively informal today. So how we're going to do it is we have three panelists with us, and we'll introduce them each before they speak. And we'll put some questions to our panelists to answer, and then we'll open up for questions. But yeah, we're hoping that this will be fairly fluid and relaxed. So I'm going to kick us off with our first panelist. She is June Cynthia Okello. June is a qualified advocate of the High Court of Kenya. She works as the Economic Governance Officer at the Pan-African Lawyers Union, also known as PALU. And June is essentially the focal point for climate justice at PALU. She has experience working at the East African Law Society as a program and legal assistant, working on regional integration and human rights. And through June's work at Palu, she has gained knowledge and experience in domestic resource mobilization issues, illicit financial flows, prudent debt management, natural resource governance, and very importantly, climate change and litigation at the East African Court of Justice and the African Court on Human and People's Rights. So June, just to confirm you are with us, could you mind putting your camera on? I hope you're able to.
Yes, can you see me?
I can't, but that doesn't mean that you aren't on.
Oh, June, I can see you.
Yes, I can too.
Excellent. Okay, wonderful. So June, let's kick off with our question to you. It's almost it's actually a cluster of questions based on your experience working within regional and international courts and your experience on the African continent with international law. Can you speak a bit to the history of African states' involvement in some international court processes? Have African states traditionally made use of and engaged actively in international court processes? How have African states responded to international court judgments in the past? So in other words, it would be really great if you could share just some key observations and trends around international courts and African states' essentially involvement in international court processes. So some key observations that might be of relevance specifically to African states' positioning and engagement with the International Court of Justice Climate Advisory Opinion. Over to you,
Thank you,
June.
Nicole. Thank you. I'd just like to confirm that you can hear me clearly because I've been having some challenges this morning.
Hear you.
Thank you. So thank you so much for having me as a representative of the Pan-African Lawyers Union. Of course, when you talk about the history of African states' involvement in international court processes, we're not talking about much, especially when it comes to climate change issues. When we talk about courts that are out of Africa, the ICC, the ICJ is not very popular with the African states. When you talk about continental courts, perhaps it's a bit popular, but we're having challenges, as we'll see as we continue with this conversation. So given the global reality of climate change and its consequences, we have treaty-based interventions or the climate pillar instruments, which have been adopted through the years. The UNFCCC, as you know, the Kyoto Protocol and the Paris Agreement, which have also been supported by a bunch of other UN resolutions, in particular Resolution 47 of stroke 24 of 2021, which reinforces the adverse impacts of climate change on the effective enjoyment of human rights, including the right to life, right to adequate food, etc. So unfortunately, Africa has only 2.3% of global cases on climate change, according to UNEP. But these cases are not actually at the continental level or at the international level. They're actually local cases which don't specifically talk about climate change directly, because when it comes to even legislation on climate change, Africa has not really gotten there. Only a few countries, we're talking about Kenya, South Africa, which have basic legislation on climate change. So it's a bit difficult to actually directly litigate on climate change, even at the continental level. So there has been no complaint or application or communication, despite the adverse consequences of climate change on human rights and the existence of quite a robust human rights system in Africa. The problem we are facing is the weak legislative frameworks, as I've mentioned, slow judicial processes, and limited financial resources. Also, when we talk about the litigation that has already been carried out, climate change comes as a secondary consideration. For example, in the Ogek case before the African Court, which was actually seconded to the Pan-African Lawyers Union by the African Commission on Human and People's Rights. The issue is actually on land, but when you look at it deeper, it's a carbon trading issue where the government prefers to sell the forest cover where an indigenous people lives, instead of actually infringing on the right of indigenous people to their land, to the indigenous land. So it's not directly connected to climate change, but it touches on climate change. So when we talk about engagement with international mechanisms, in Africa, unfortunately, there has not been any litigation at the continental level. We're talking about the African Commission or the African Court on Human and People's Rights on climate change specifically. This comes because there's a limitation as to approaching these continental level mechanisms. I'm talking about continental level actually, because when you talk about ICJ, ICC, the African states are not known to actually engage with these mechanisms. When you put climate change aside, when you talk about the ICC, Africa has actually not had a great reputation in the ICC because Africa feels like they're being targeted by the ICC since its establishment in 2002. So there's a little bit of bitterness there. And so Africa is not really welcoming to the international. When I talk about international now, talking about the out of the continent mechanisms. So we are just limited to the continental processes, beginning with the African Court at the Commission, which have been established by the African Charter and the African Court Protocol, African Commission. And then we come down to the regional level courts, that is the East African Court of Justice, that is established by the East African Community Treaty. We have the African Committee of Experts on the Rights and Welfare of the Child. We have the ECOWAS Court of Justice. So these are regional level courts, which don't really handle much of climate change cases as we know it. So when you talk about climate justice, we could talk about compensation for past harms committed by the historical polluters as we know them, that is the global north countries, the allocation of present and future responsibilities, that is distributive justice, and the adoption of fair procedures as an inclusive framework in the decision-making process, that is procedural justice. So, there has been a total of 5 requests for advisory opinions. That is at the Inter-American Court of Human Rights, which rendered an advisory opinion in 2017 on states' extraterritorial obligations to refrain from committing environmental harm. The second one was at the Inter-American Court on Human Rights, which received a similar request in early 2023. From Chile and Colombia as we know it, which is yet to be determined. We have the ICJ request by the UN General Assembly, which is also yet to be determined. And another request at the International Tribunal for the Law of the Sea, which has actually already been determined. And it was brought up by Vanuatu, which is a small island state, basically arguing the effects of climate change on small island states all over the world. So the 5th one is actually an attempt by African CSOs to bring a request for an advisory opinion at the African Court, which actually we've had this conversation with Natural Justice and a couple of other organizations, because at the continental level, we need an advisory opinion to actually give us some sort of directions as we all know, advisory opinions are not binding upon anyone or any state, but they do give, it's a basis for advocacy to actually give directions to states on their obligations when it comes to climate change, their obligations on human rights when it comes to climate change. So it will be an advocacy basis when we get an advisory opinion of such a nature, and actually persuade African states, even at the AU level, when they're engaging with other countries, even at the COP meetings, so that we can actually have a basis of our arguments when we're asking for compensation, when we're asking for support to deal with the climate crisis that we're facing at this time. So when you talk about the judgments that we've received from these regional and continental level courts, African states are not known to actually implement judgments. At the Pan-African Lawyers Union, we've gotten several favorable judgments against different African states, for example, in the OGEC case against Kenya. And unfortunately, implementation is yet to be done. We're having a problem with the implementation. I mean, we have lovely treaty instruments. We have courts that are funded, well-funded. We have competent, we can call them competent judges, sitting at these courts, issuing very beautiful judgments, but states in Africa, as we know it, do not want to implement. Instead, they come back with threats of withdrawing from these courts. Like in Kenya, the head of state recently just made a remark that if the African court does not withdraw the injunction on the issued in the OGEC case, then he was threatening to withdraw Kenya from the African court. So these kinds of issues are actually making it very difficult to litigate at the African level. But it's also interesting to note that remedies do not actually need to come from the continental level. Remedies can actually come from other courts out of the continent. For example, the Court of Appeal at The Hague actually recently issued a very favorable judgment. Sorry, I'm just trying to find that. In 2021, the Hague Court of Appeal had handed down 3 judgments relating to a long-standing community-led battle against Shell's oil polluting operations in Nigeria. So the court ordered Shell to pay compensation for damage caused in Nigeria, thereby establishing a precedent for a court based in Europe to grant damages for harm by a multinational in a developing country. So such a precedent may open the gateway for litigation regarding African climate change impacts and or damages in other jurisdictions, which may have more favorable outcomes than in courts of the impacted states, where there may be concerns around judicial capacity or unsupportive legal frameworks. So there's also the Ganvo and Glencore corruption cases, which of course do not touch on climate change, but there are good examples that you can actually litigate in foreign courts on issues or effects of actions of those companies registered in those foreign countries, but benefit the state where the crimes or the actions that infringe on human rights were committed. So at the end of the day, I don't want to go on and on. Perhaps I'll give people the chance to ask questions, but we need to know how we could frame legislation to reflect climate justice obligations of states. Also, we could think about what can be done better at AU level to compel the global North countries to fulfill obligations and commitments under international treaties. So I'll stop there and just give my fellow panelists a chance. Thank you.
Thank you so much, June, for your perspective and thoughts on Africa's really disappointing engagement when it comes to some of these international court processes. I think we all are aware of Africa's complex relationship with these international courts generally, whether it's because of colonial histories or just wariness generally because of the political dynamics or diplomatic dynamics that color those sorts of engagements. But I think what sticks out from your views and your thoughts today is basically emphasizing the fact that in 2024, post-democracy, in most parts of Africa at least, what we should really be seeing is the continent taking a more active role when it comes to, its engagement with these dialogues, when it comes to climate justice specifically. Otherwise, this posture of refraining from engagement will lead it to it not being able to protect the interests of the continent, which is very key. Allow me now to introduce our next speaker. Her name is Lorraine Chuponda. Lorraine has been in the climate and energy justice space for nearly a decade, engaging with a broad spectrum of African civil society organizations and groups, as well as strengthening and supporting a just and equitable phase out of fossil fuels towards clean energy. She's worked before as the coordinator of the Africa Core Network, which I'm sure some of our audience members are familiar with, as well as being a facilitator for the Africa Movement Building Space and co-facilitator of the Don't Gas Africa campaign, which is a huge campaign on the continent and known globally, generally. In addition to disrupting the fossil fuel economy and building strong networks, pushing out the phase of fossil fuels, Lorraine has also supported winning campaigns in various African countries that have managed to cut financial flows to fossil fuels such as coal, gas, and used various methodologies to push for clean energy that include advocacy, government, and financial institutions engagement. Lorraine has served in the ICBC campaign as a steering committee member and is a global advisor to the Climate Critical Earth. Lorraine is a regional advisor to Community Resource Exchange and sits in the Global Steering Committee for the Rights and Development Coalition. We've asked Lorraine to basically paint a picture for us for why climate change is a challenge, particularly for African states, and to really speak about the complexities that are faced on a day-to-day in Africa when it comes to this topic. We also want to hear from you, Lorraine, really what climate justice for Africa looks like from the African perspective. So Lorraine, please take the floor.
Thank you very much, Noma, for that amazing introduction. And also thank you to you and your team for organizing this meeting. So I'm going to start by just mentioning or stating the obvious, maybe not to others, but in my space, I'm sure, a lot of people know that the climate crisis is as a result of, it's a symptom of failing growth and developmental models that, many countries, including rich countries in the global north, have continued to clutch on despite us seeing the evidence of the ever-increasing climate crisis, which has only increased in intensity and frequency over the last few years. And Africa itself, now zoning into Africa, Africa is faced with various forms of threats. Taking aside the climate crisis, we all know that the African continent has got, a huge developmental crisis that it is facing because of the continuation of poverty, the continuation of operating in systems that do not benefit African states, including extractive models and global systems, global financial architecture systems that do not benefit the continent. Other forms of crisis include also the energy poverty in Africa, the unending conflict in Africa. And now we've got in the same mix, the climate crisis, which then is compounding, the already existing issues and crises that affect Africa. So now this is the context in which, the climate crisis is happening in Africa. I'm sure we've seen the evidence of climate disasters across the continent. And from the disasters and also the climate crisis, we've seen that the climate crisis has affected various facets of people's lives on the African continent. The climate crisis is affecting food systems in Africa, whereby our existing food systems and how we have produced food is under threat, first because of industrial agriculture, which diminishes climate resilience, affect the fertility of our African soils. And then again, our water systems are again affected by the climate crisis, because where there are droughts, where the industries continue to engage in extractive systems that pollute water through production or extraction of fossil fuels, it means again our water systems are affected by the same pollution, by that same use of water. If you look at what is happening or what can potentially happen in Namibia, is that we're seeing fossil corporations bidding to try and extract oil. If you look at Recon, it's already now starting its operations in Namibia, in the Okavango Basin, right? An area which is rich in biodiversity. And again, looking at the context of Namibia, it's also partly desert. And then again, we're still seeing, projects that will continue to result in stress in terms of water access for people. Again, there are various offshore projects, right, which are going to displace people across the African continent. We all know that our food systems are under threat because of the crisis. Now we've got the fossil industry again coming into play, resulting in various other strains on the same resources that are needed by African communities to access food. Again, the climate crisis affects the health of our people. If you look at communities that host some of the extractive projects, fossil projects that continue to emit emissions into the atmosphere, the same emissions are not only going to affect the ozone layer or cause global warming or cause climate change, they are also releasing emissions that are affecting the health of communities in that host these projects. If you look at South Africa and the Mpumalanga province, it's one of the most polluted areas across the globe. And we're seeing more of these projects. If you look at Hwange, various organizations such as the Hwange Residents Trust have been pushing to ensure that air quality management is done in a way that allows communities to breathe fresh air. So these are some of the challenges that we're facing by following a system, a development model that does not speak to the needs of African people, that does not speak to what is needed in terms of growth and also prosperity for African communities, right? So now again, still getting back to the first part of the question, right? Africa needs adequate finance, adequate resources, technology, strong policies, and democratic systems and governance at the core, as well as involvement and participation of vulnerable groups. Now, I want to touch on democratic systems and strong policies. We all know that various groups across Africa have been fighting for climate justice by pushing back on fossil and extractive projects, by fighting off some of the projects and investors that continue to support projects that are directly linked to the climate crisis, right? And we all know that because of our weak and still developing democratic systems, many of our activists face threats day in, day out because of fighting for climate justice. So again, this forms part of the context under which African communities are facing, where they try to fight the climate crisis through various areas and various platforms. They face the threat. Their lives are placed at threat, right, in trying to protect and assert their rights. So again, in order for us to then go to the second part of the question on what climate justice for Africa should look like, right? Climate justice means that, right, African communities can access their rights, right, can have the adequate democratic spaces to influence various decisions that are made by their own African governments, including what type of energy projects to invest in, including, what the development trajectory that their own governments are going to follow after. And then one other aspect, right, is that climate justice has to encompass all forms of justice, right? Because like I mentioned earlier on, various facets of African people's lives have been affected by the climate crisis, which means African communities are also pushing for restorative justice, right? Where our environments that have been affected by the climate crisis, where our communities, our land, our water systems, our food have been affected by the climate justice are restored, rehabilitated, and also placed in a position where African communities are continuously able to access their livelihoods, to access their health as well. Another aspect is redistributive justice, right? I mentioned earlier on that we are operating in a context and a system where, the issues to do with the racial justice, and now we need to ensure that there's redistributive justice. Rich nations that have continued to plunder the environment and cause the climate crisis need now to pay reparations to the same African communities that have not depleted the atmosphere, that have not taken part in emissions. And importantly, Africa needs to drop the extractive sector in its current form, which is violating community rights, resulting in displacement from land, resulting in water pollution, right? Therefore, climate justice means a new agenda should be set for Africa and the globe at large, which accounts for various justice aspects I've mentioned, including gender justice, energy justice, where we do not only extract energy to take it out for the consumption of rich nations, but where, again, the same resources are used to ensure African people have access to energy, have food sovereignty, whereby they're able to decide how to produce, how to consume their own food, and rich and polluting nations own up to paying up for the depletion of the ozone layer. If I leave this aspect out, it means I wouldn't have done justice as well. We need a new finance architecture which cancels debt and avails cheap money for African countries. And again, importantly, to fight for solutions. I won't mention much because I think I only have a few minutes, but we need to fight for solutions, which we have been seeing. The same countries, the same companies, corporations that have depleted the atmosphere are now pushing for solutions where they are not held accountable. They are now pushing for solutions which do not speak to the justice issues which affect communities who sit at the front lines of the climate crisis. Some of the solutions include even carbon markets, right? Carbon markets are resulting in loss of land, loss of sovereignty, loss of access to forests that have previously been owned and have benefited African communities. And so we are seeing that carbon markets are not a solution to African needs. We're seeing solutions around carbon capture and storage, which are taking away resources and finance from where it is needed, right? And so we need to continuously push for justice, which speaks to various needs, which speaks to the climate crisis that we are faced with. I know various organizations have been pushing towards at regional and global processes, such as the Conference of Parties, the COP, which has somewhat managed to shift the focus of global governments to agree to phase out fossil fuels. But we still need to do more in ensuring that African communities receive the technology that is needed for the transition. They have access to renewable energy, and we do away with an extractive and polluting systems. I think I'll end here and give it back to Norma. Thank you.
Thanks, Lorraine. I'm actually going to hand it back over to Nicole. Nicole, go ahead.
No, that's fine. Thanks, Lorraine. And thank you for highlighting why the climate crisis is such a massive and large-scale crisis for the African continent specifically, not just from a human rights infringement perspective, but also from a socioeconomic perspective. I'm going to introduce our next speaker, Christopher Ward, but maybe just before I do that, I just want to give a brief background to people who are listening who might not be that familiar with the background of these international court processes in relation to climate change that we're talking about specifically today. So maybe just briefly in terms of the we recently got a very progressive and good decision from the International Tribunal for the Law of the Sea, particularly on essentially state parties' obligations in relation to climate change on the UN Convention on the Law of the Sea. So what that means is that the tribunal was asked to give an opinion on the obligations of state parties to prevent, reduce, and control pollution of the marine environment, essentially in relation to climate change. And what the tribunal essentially found was that state parties have an obligation to take all necessary measures to prevent, reduce, control marine pollution from anthropogenic greenhouse gas emissions, that this is an obligation stemming from due diligence, and that the standard of due diligence is stringent. There's a very lengthy judgment from the tribunal, but the prognosis is essentially that the tribunal took quite a progressive opinion and stance in relation to state obligations to address climate change when it comes to protecting the marine environment. And then parallel to this process, there are a number of essentially requests at the moment in various international forums for advisory opinions on state obligations to address climate change. And at the same time, there's also the International Court of Justice has also been asked to give an advisory opinion on state obligations to essentially address climate change, and what these state obligations are under international law, and what are the legal obligations, what are the legal consequences under these obligations, where states, through their acts or omissions, have caused significant harm to the climate system. So these are the kinds of things that international courts are now being asked to consider. And essentially in March, a number of states had the opportunity to make submissions to the International Court of Justice. Now in August, states that have made submissions will have an opportunity on the 15th of August to respond to those submissions that states have made. Unfortunately, the process within the International Court of Justice is quite, it's not very public. So we as civil society have not really had an opportunity to interrogate what various states have said. But what we do know is that some states are taking a conservative approach in terms of which they're arguing that state obligations to address climate change are only those obligations that are imposed under the Paris Agreement and the specific conventions on climate change, no further. Whereas other states are taking a much more progressive approach, arguing that because climate change is an issue which affects numerous human rights, we need to take a much broader look at what that means in terms of states' obligations to protect human rights under international human rights law, what that means in terms of obligations to address climate change. So the process before the ICJ, the International Court of Justice, has not yet unfolded. That process has not yet gone for hearing. And once the hearings in that process commence, we anticipate that the submissions made by various states will be made public, and then it will be a lot clearer what positions various states have made. But the point today is that this is a very important process for climate justice, for securing climate justice, potentially within Africa. And in getting to that process, we'll be hearing a bit from Christopher. And hopefully we'll get into that in our discussion process, why this is important for African states in particular. So I'm now going to introduce our next speaker, Dr. Christopher Ward. Christopher is a senior counsel at the Australian Bar, and Christopher is going to be joining us today because he has many years of experience practicing in international law. Christopher is an honorary professor of international law at the Australian National University. He publishes and speaks widely on matters of international law. He was the global president of the International Law Association from 2018 to 2020. And Christopher works in all areas of public international law as an advocate and an advisor to governments, NGOs, and corporations, and he appears in international and domestic tribunals and courts. And Christopher has particular expertise on the law of the sea, climate change, maritime boundaries, and human rights. So thank you very much for joining us today, Christopher. So our questions for you are essentially, what do African states stand to gain or to lose from the advisory opinions on international law obligations on climate? And particularly the ITLAS opinion, the International Tribunal for the Law of the Sea, the recent advisory opinion there, and the opinion that is going to be coming from the International Court of Justice. So what are the opportunities and what are the risks for Africa that could flow from some of these decisions? In other words, and put more simply, why do these advisory opinions on climate change matter for African states in particular? Do they matter for African states? Over to you, Christopher. Thank you.
Thanks, Nicole, and hello everybody. I'm in Sydney today. I work both in Sydney and London, but I'm in Sydney tonight, Sydney time. So greetings from Sydney. Those are really interesting questions, and my chambers, both in Sydney and in London, have participated in both the ITLOS and the ICJ proceedings that are currently underway. And we've also had some involvement in the European Court of Human Rights proceedings that were recently decided as well, which some of the audience might be aware of, in which both some young people sought to bring proceedings against Portugal relating to climate change, and some elderly people from other European countries also brought proceedings. The young people's proceedings in the European Court of Justice, European Court of Human Rights, failed. But even in the course of failing, very positive things were said about the nature of climate responsibility and the overwhelming threat that climate change represents to the international community at large. And so the answer to the question, Nicole, why does it matter and what are the benefits to the African continent for being involved in these processes, that the courts are lending a new impetus, a new legitimacy to climate activism. So for many years, climate change work has really revolved around diplomacy and the negotiation of treaties, leading, of course, to treaties such as the Paris Agreement. But the international tribunal proceedings are quite different. The international tribunal proceedings, even though advisory in nature, and I'll come back to what is the significance of the advisory opinions, but the international tribunal proceedings are broadening the scope of climate activism from simply focusing upon the reduction of emissions to instead looking at the much broader impacts of climate change, the legal significance beyond simply reduction of emissions, to the effects and how to counter those effects. And they include things, for example, the ITLOS Tribunal for the Law of the Sea decision that was handed down a couple of months ago focuses upon the United Nations Convention on the Law of the Sea and definitively found that atmospheric pollution also constituted marine pollution because the oceans, as we know, are a heat sink, and the effect upon the oceans includes deoxygenation and acidification, as well as sea level rise. And so you have consequential effects in the oceans, including on fishing and territorial boundaries, as well as simply the loss of oceans as an undisturbed resource of humanity. So we have, in the case of the ITLOS proceedings, an advisory opinion which has now extended the effects of climate change into the law of the sea. The International Court of Justice advisory opinion request is even broader than that. So the International Court of Justice advisory opinion request, which has been made by the General Assembly, again on the initiative initially of Vanuatu and even some young people in Vanuatu. But the ICJ has been asked to advise on the obligations of states to ensure the protection of the climate system, but also what are the legal consequences as a result of those obligations for states where they have already caused significant harm to the climate system. And what are the obligations of states in relation to peoples and individuals of present and future generations affected by the adverse effects of climate change? So it's an extraordinarily broad question that the ICJ has been asked. And it's quite unique in that sense. Never before has an international tribunal been asked to consider the full breadth of the effects of climate change. And that's of particular significance, I think, for the African continent. First, because as we all know, Africa bears the burden of climate change in a particularly significant way, but the African continent is not the cause of climate change. And there's a real inequality in the harm and causation, which is particularly obvious in the African continent. The second reason it's significant for Africa is that the effects of climate change within Africa are not uniform. Different states in Africa will face quite different consequences. Some will face flooding, some will face desertification, and many will face food shortages as a result in relation to food production. Coastal states might face the consequences of territorial boundaries moving as a result of sea level rise. Fishing states will suffer the result of migration of fishing species and the loss of fish as a result of deoxygenation. So although the effects upon the African continent are comprehensive, they are extremely varied. And as the IPCC has explained, those varied impacts in the African continent require differential attacks and differential approaches to resolve. The ICJ proceedings are an opportunity for African states to place those differential impacts before a tribunal and to have the tribunal determine and resolve what are the obligations of polluting states in those varied implications in Africa. And as part of what the ICJ is looking at, there will be human rights implications which are directly raised for the first time. And although the IPCC has been looking at human rights in its work, this will be the first time that an international tribunal can really raise and consider human rights implications, including in particular the implications of climate change and water scarcity on women and children in a legal setting. And just to give you an example of how that might play out in the ICJ advisory opinion, as you probably are aware, the court gave an advisory opinion in relation to Palestine just last Friday. And in one of the significant judgments of 4 members of the court, the problem of water scarcity in Palestine and the particular problem of water scarcity as applied to women and children was a significant matter considered by the court. And so I think that the opportunities for African states to participate through the African Union and other states that have involved themselves in the proceedings are very clear. And it's very important that the African continent takes this opportunity and moves forward with as much as possible one voice when it comes to identifying the impacts on African people and the impacts upon African states as a result of climate change that originates outside Africa. The changes in weather patterns and circulating pressure systems and water currents are inevitably going to impact the continent of Africa in a physical sense. And that will, of course, place population pressures at a very significant scale, leading to probably migration impacts as well as other significant human rights implications. And so the risk for Africa, if the continent does not fully participate in these proceedings, is that the rules will be made around Africa. The rules will be made without a full acknowledgement of the effect upon this great continent and the people in it. And that's something that I think really does need to be the focus of African leaders and, of course, the community of NGOs, which I know are just dying to get their hands on the submissions, and as we all are, of all other states, to see exactly what is being said to the court. But that, I think, is the answer to those 2 questions.
Thank you, Chris. So I don't see any or too many questions. I think Norma and I have probably enough questions to ask all of you to to fill the time. But if I may, just to follow on, and I suppose this is very much related to the point that Lorraine was making about, this is very much about climate justice for Africa as well. As you've said already, Chris, Africa has contributed the least to the problem, and yet it stands to bear the consequences the worst. And the reality is that many African countries simply don't have the resources to respond adequately to climate change. And African states are ultimately responsible for protecting the human rights of the people living in their countries. And yet they're simply not resourced to respond. unfortunately, African states are being plunged further and further into debt as a result of having to take out loans from specifically the countries that are, historically responsible for these, for the majority of emissions. So it's really a bigger issue as well of justice, of climate justice here. And I suppose this relates to the second question before the ICJ, the question of the legal consequences. So traditionally and typically the thing that we're seeing most African states concerned about in relation to climate change is getting financing, getting money from the north, from the well-resourced countries that are historically responsible, getting the financial support essentially that they need in order to address loss and damage, in order to address climate impacts, and to be able to respond appropriately. So do you think that there's scope within this ICJ process to get some real movement on the question of reparations, on the question of essentially money flowing from the well-resourced, historically responsible countries to the African states that need money very much in order to be able to respond? It's not, of course, only about money, and as you say, it's very much about recognizing human rights impacts, but in terms of why African states should care, I think it's an important point. I don't know that many African states are aware that this decision, this ICJ advisory opinion, might have the scope, or maybe it doesn't, maybe it does, to unlock the very much needed financial support, and one could call it reparations, compensation that is needed to respond to the climate crisis. Do you think that that's a fair comment to make? Do you think that there is a scope within this ICJ advisory opinion process to address that issue?
Definitely, and the ITLOS Law of the Sea Tribunal decision goes some way towards clarifying that as well, by identifying the liability of states as being a potential outcome. I think it's very likely that there will be two stages to this litigious process, and I think we're almost at the foot of the second stage now, which will be state-to-state claims made directly by affected states against polluting states. And I think that the ICJ advisory opinion might set the framework for those state-to-state claims, but there's nothing to stop them being brought now. And I think the law is already becoming clear enough that there is a liability that flows from pollution on the basis of existing transboundary harm law, which has been quite well understood for at least 50 or 60 years, but I think now is being given new life in the context of climate change. So my answer is yes, definitely. I think the ICJ opinion will directly address reparations and is likely to do so in a way that's helpful to those states that are burdened with the effects of climate change.
Excellent. Thank you, Chris. Norma, do you want to come in here with any questions? I do see we have a hand. So I'm wondering how you want to proceed, my co-facilitator.
I'll use your discretion. I'm happy to ask the question or to allow the specific, maybe the audience member first, and then I'll direct my question back to Dr. Ward and Lorraine afterwards.
Excellent. Okay, so I see we have a question from Taufik. You have a hand raised, so I'm just going to give you the floor to ask a question. I think you should be able to unmute yourself now. There we go.
Yeah, good morning, everyone. And thank you so much for this wonderful event. I must say I enjoy every discussion from the panelists. Yeah, I just want to speak briefly. It's not really a question. I just want to give another dimension or a perspective about the issue being discussed. My name is Taufik Alatiche, and I'm the legal advisor of the climate justice. So I just want to speak briefly on the issues around climate justice in Africa, and why we have not really. Yes, can you hear me?
But could you say it again? I missed a bit of that, and I'd like to hear it.
Yeah.
Hello, can you hear me?
We can hear you now. Go ahead.
All right, thank you so much. So, like I said, in Africa, we have too many problems. I mean, around legal, I mean, social, and so many issues. So, with respect to climate change, the reason why we've not had enough cases in Africa is because of we have a justice issue, we have legal issues, and which are largely weak legislation. Access to justice is very weak. We have a judicial process that is not responding adequately to the needs of the people. With the political process, the leader are also not seeing climate change as an existential problem that require urgent attention. And that is a big problem. And that is why when you look at the legal framework, especially at the African continent, we have not had enough cases. And because if you look at the African human rights system, especially the African Court of Justice and the African Commission, the procedure for individuals or groups to access those courts is very difficult. And that is why, and that is the major reason why it is very difficult for community and individuals to approach those courts. Now, one of the issues is that we have the procedural challenge. The procedural challenge is a big problem because to have access to African court, the law provides that you must first go to your local court, which is the court in your country, to take advantage of the local remedies there before you can come to the court at the continental level. And that is a big problem because at the local level, individuals have challenge to access their local courts because of the challenges to access to justice, slow judicial process, finance, and so many big issues. So because there are no enough cases at the national level, it becomes difficult to seize the jurisdiction at the African continent because at the African regional level, because that is a condition precedent that has to be fulfilled. And that will also affect other international courts. Access to those international courts will also require that we also exhaust the remedies at the local level. For instance, the United Nations Human Rights Committee is also a very important court that can address some of these challenges, as we have seen in Australia, the Torres Strait Island case, where the indigenous people in Australia approach that particular court to resolve issues around climate change in Australia. So Africa, we have this existential problem, and around political leaders recognizing the urgency of climate change, our judicial process is very weak, and that is why it is very much difficult for us to participate at the international level when it comes to litigation. Now, the current ICJ opinion that we are expecting, if you look at it critically, you see that African countries did not fully participate in the process, and this is very discouraging in the sense that the problem facing Vanuatu and other small island states is also facing Africa as a continent. We have small island states in Africa who are at the risk of climate change. We have a flooding, sea level rise is an essential threat to a lot of people. And in spite of this, we are having not much serious attention from leaders participating at the international level in terms of negotiation or even litigation. So you can see that this problem is weaved around two important issues. Now, the political will from the African leaders, and then even when the citizens of Africa wants to take those issues to court, they also have problems at the court level. So I hope that in spite of the disadvantage within African system, we can have, maybe when we have the decision of ICJ really making this bold pronouncement that nations around the world have an obligation to address climate change, then we can maybe, just maybe, we can have momentum in Africa. But like one of the speakers mentioned, the problem of Africa will have to be solved by Africans. We need to solve it at the continental level, because that is where the problem is. Thank you so much.
Thank you so much, Taufik. I hope I'm pronouncing your name correctly. You made a good point there, and you asked a question about, the procedural issues sometimes when you are first exhausting your internal remedies domestically before approaching a regional court or an international court. Perhaps June can come in and clarify for us whether that's necessary in all instances. I know there's probably some procedural rules that might afford you an opportunity in instances where there is such obvious prejudice in a domestic court, and so much so that it negates actually investigating or exploring using your domestic remedies, that you can actually go to a regional court as your court of first instance. But I think June can come in there and maybe clarify for us whether that is indeed the case with one or two courts. I had a question for Dr. Ward as well as for Lorraine. I'm going to ask both of the questions at the same time now, and then perhaps Dr. Ward, you can start first, and then I'll give Lorraine an opportunity to answer. You mentioned specifically a lot of really staggering impacts when it came to the climate crisis on Africa, and you didn't focus just on the socioeconomic perspective. So not just issues about food insecurity or loss of life, but you went into issues that are more interesting to African politicians, like the loss of territory, so boundaries shifting and moving, the loss of economic strongholds, maybe for a fishing state or a state that exports, flowers. Do you see this issue of the climate crisis being a bigger part of Africa's foreign policy profile? Territories and boundaries are such a huge and an important issue to a state because they affect its sovereignty, its identity in and of itself. Can we use that as leverage to get more African leaders a little bit more involved in taking the issue of the climate crisis more seriously, do you think? If we make it less of a human rights issue, more for a foreign policy issue, and sort of, something that the state should take into account. And then Lorraine, you also went into detail on the failing democratic systems in Africa, failing rule of law, and a lack of strong policies on the climate crisis. From your side, how do you think international lawyers or African lawyers that are specialized in international law can rope in a lot more African communities and galvanize them so that they know a lot more about these ongoing international court processes, and then they can actually place pressure on their governments to put their interests at the forefront when they're engaging with the court systems? A lot of these court processes only allow for representation at state level, so we don't really see a lot of engagement from the African community in and of itself, making its way to the court papers. So those are the two questions.
I think you wanted me to go first, so let me just answer briefly. First of all, yes, I think it can be framed effectively in terms of sovereignty, although not all of the states will be affected in the same way, but there's certainly potential. And one of the things that the small island Pacific states have done very well, both in ITLOS and in the ICJ proceedings, is to frame the effect of climate change upon them as one that goes to sovereignty itself and to their very statehood. And that has raised the issue beyond a human rights issue, not that there's anything intrinsically small or low level about a human rights issue, but they've raised it to the level of the effect upon sovereignty itself. And it's quite possible, given the content of the IPCC reports, it's quite possible that changes to rivers and water scarcity will be very significant issues for African states that will affect the viability of populations moving forward over a 50 to 100 to 200 year time frame. And so I think that is something that is scientifically valid and that does give rise to precisely those sorts of consequences and issues which could be raised by African leaders. I might just simply say too, in relation to the question of exhaustion of local remedies, that of course that is absolutely fundamental to the commencement of claims against states, particularly in the context of what we call diplomatic representation cases, where we're asserting individual rights against a state. It's less so in state-to-state claims, where one state is claiming directly against another state for the consequences of climate change, and it's not relevant to the consequences of climate change in an advisory opinion scenario. So it's a very valid point when it comes to utilising the individual remedies that are available, for example, in the United Nations Human Rights Committee and other tribunals that allow for direct access, but less so in the advisory opinion and state-to-state tribunal scenario.
Thanks, Dr. Wood. Go on, Lorraine.
Thank you for your question. So I want to first highlight that some of our governments are actually accomplices, especially political elites that in most cases find themselves collaborating with some of the corporations or projects that actually affect community rights with regards to access to their territories and also boundaries. So I think we have to kind of, be clear that it's not all rosy with our African leaders. Some of them, are in partnership and comply with some of the projects or activities that actually infringe on community rights. And because some of our African governments align with those corporations or governments or countries that want to usurp community lands and water resources, it also means then they use some of the other draconian laws to actually inhibit access of rights for communities, right? If you look at the right to demonstrate, the right to act in various actions, even the right to live in a secure land, many of the areas where communities are fighting for climate justice or pushing back on projects that affect their climate resilience are actually more of them in some of the context militarized, right? So it means political elites are using the military, they're using state power to actually infringe on the rights of communities and also influence their territories and also boundaries. So again, in as much as we have to take steps to engage our parliaments, especially with regards to training of parliamentarians on various laws, and also seeing where we can expand various laws and regulations that they benefit communities, we also need to place the law in the hands of communities and continuously push back on some of the boundaries that inhibit communities from accessing their rights by training communities, making the law, ensuring that communities can actually access and define their rights with regards to their territories. I know Natural Justice has worked on community biocultural protocols, whereby communities are actually able to assert their rights with regards to their territories and boundaries. So again, there's still a lot of work that needs to be done around African policies and also regulations. Some of them don't have clear definition on various other rights. If you look at what it means to ensure that there's wide participation, many of the laws just end it. There's need for wide participation, but what that actually entails or means is not very clear. So again, there's a lot of vagueness, there's a lot of blurred lines in many of the African laws. And so while we're embracing the good parts of African systems and laws and policies, we also need to be able to continuously identify the gaps and call out and call out where there are violations. I want to point out, some of the benefits that can come out if, African states also, work together with communities affected and communities fighting for climate justice. With regards to the just energy transition partnerships that have been rolled out in South Africa and Senegal, right? These are some of the platforms which African states can actually push for some of the issues around finance, getting cheap money, cancellation of debt, ensuring access to technology. Some of these partnerships that are being drafted to try and mitigate the climate crisis can actually, pave way for climate justice for African communities. But this can only be done if there are careful steps that are taken to ensure inclusive participation of affected individuals. There's access of laws and regulations by people that are at the front lines of the crisis. So yes, there's that possibility again to strengthen that aspect in terms of policies and regulations that support communities, and also to expand on democratic systems in Africa, where also it is made a prerequisite to say that, the type of finance that will come into Africa, in as much as it is going to be grants or cheap, it should include a clause where democratic rights are embraced in many of the partnerships as well, so that it strengthens our democratic systems as well, in as much as we're pushing for a just transition towards renewable energy in a way that mitigates the climate crisis. This needs to embrace democracy and governance for many of the African states. Thank you, and back to you.
Thanks, Lorraine. June, did you want to come in with any any responses to any of those points, or Rosaline, for that matter? And maybe just while I have the floor, I'll also just read out that we have a question from Samira, which is, do you think that this advisory opinion could have an impact on the way, on the way we'll deal with conflicts where climate or environmental issues are at the root of the conflicts, or conflicts that have an impact on the environment? I'm happy to come in on that, but I think I'll give the floor to our speakers first, particularly June or Rosaline, if you have any thoughts on any of the previous questions or this one.
Thank you, Nicole. Thank you, Norma. I just wanted to respond to Taufik. I don't know if I pronounced his name correctly. Yeah, Taufik raised a very important issue, perhaps, that I had failed to mention. The fact that African jurisprudence is really lagging behind when it comes to climate change. And this perhaps translates to the fact that Africa does not really have a common African position when it comes to climate change issues. They have not taken a stand legally on these climate issues because, first of all, we're having a problem with access to justice. We're having weak legislation. And when you talk about access to justice, the issue is the fact that our African court is the African Court on Human and People's Rights. That's where we intend to file the request for an advisory opinion. But how accessible is the African Court? How accessible is the African Commission on Human and People's Rights? First of all, you have to exhaust local remedies, but these are the local remedies which have been, to say the least, not able to actually provide the remedies that we require. So most people would like to avoid the local route, but the African Court forces you, and the African Commission also forces you to go back to your local courts and seek remedy from there, from the lowest court to the apex court. And when you've exhausted those remedies, that's when you can come to us, the African Court, and that's when we can give you the floor and listen to your application. Another issue is the fact that you have to be directly affected. You have to be the direct victim of certain acts or omissions before you file a case at the African Court or African Commission. But as jurisprudence in the court continues to grow, I think we've seen CSOs being able to bring those cases at the African Court and Commission. So as time goes, things are changing slowly, but we're still having that problem of access to justice. Another issue is the fact that you must have an observer status with the AU or have signed a memorandum of understanding with the AU for you to file a request for an advisory opinion at the African Court. With this, I know as it stands right now, I know that PALU is, according to the best of my knowledge, is that PALU is the only organization that has been allowed to bring requests for advisory opinion, an organization that is not an AU organ as it stands right now. And that is a problem, because what if another organization or another person wants to file a request for an advisory opinion at the African Court, they're denied such access? As we know it, 15 advisory opinions have been filed at the African Court, but only 4 have been accepted, and an advisory opinion have been issued on those cases. So you see, even when you talk about trying to build the jurisprudence on climate change, it has proven very difficult, and it is also politically motivated, the way the structures of these courts have been established, because it's like having clawback clauses on these instruments. You're being told you have the freedom of expression, but you're being told subject to compliance with national laws. And these national laws, as we know them, most of them are very unfair or unconstitutional. So when you seek remedy at the continental level and you're told, no, please go back to your local laws, and you're trying to escape those local laws, then we are having an issue there. So at this juncture, I wanted to mention the procedural issue that Taufik had mentioned. I think Natural Justice actually experienced it firsthand at the East African Court of Justice, where you bring a very substantial issue to the court, but the court chooses to rule on a procedural issue. The fact that the East African Court of Justice requires you to have filed a complaint within 60 days of the act or omission being complained of. So how do you then calculate 60 days from the day you felt the effect of climate change? Or how do you then calculate 60 days from the day? It's a very difficult calculation to make, and it really limits access to justice at the East African Court of Justice, because then what if, climate change did not start yesterday, did not start 2 years ago, it started a long time ago, the issues that you're facing right now. So they decided to throw out the case on the issue of time. And unfortunately, we see this even in local courts. They don't want to address the substantial issues being raised by people who actually understand the climate change issues. They want to actually rule on the procedural issues and any other thing that may arise, but not the substantial issues. So this is something that definitely is a challenge that we're facing right now in Africa, and that's why our jurisprudence is not growing as quickly as it should. Thank you.
Thanks, June. And maybe, Rosaline, I don't know if you have any final remarks before I hand back to Norma to close.
Thank you all. No final remarks in terms of answering any question or anything, but just to thank everyone for making the time out to attend this webinar and for all the insightful contributions and sessions from the panelists. Thank you all so much.
Thank you. And maybe just a sort of closing reflection. I think we also, I think climate litigation in Africa and in the global south looks very different to the kinds of climate cases we've seen happen domestically in Europe and in North America, where, of course, the emissions are much higher. Africa is responsible for less than 4% of global emissions. So the kinds of cases that we'll see playing out in Africa aren't really going to be focused on cases to get governments to reduce their emissions, because in many countries their emissions are so low. The cases in Africa are much more focused on climate issues that don't necessarily mention climate issues around access to water, access to food security. And maybe this links quite nicely with the question you made there, Samira, about conflicts over water and food. I think the challenge now is drawing that link to climate change, because those are the kinds of issues we're seeing play out a lot. And while climate change isn't mentioned in a lot of cases that are happening in Africa around access to food, water, damages relating to floods, those are climate issues. So I think it's also just recognizing that the climate justice cases on this continent are different. But there's inherently a climate justice component to these issues. And of course, in Africa, the issue of energy access is a major issue as well. And many African countries are saying, well, we should be allowed to exploit our fossil fuel resources in order to give people access to energy. And so I think as civil society, we have a bit of a challenge on our hands to ensure that people have access to energy that is clean, that is affordable, and that is not from fossil fuels. But many of the people on this webinar already know that. So I think it's time to close the session. Thank you so much to our panelists, and I'm going to hand it over to Norma to close for us.
Thank you so much, Nicole. It's been an absolute pleasure hosting this webinar with you. I don't think I could have said it as well as you did. The fact that for Africa, it is really a multifaceted approach, because the tentacles of this climate crisis, as you mentioned already earlier on, find their ways into different sectors of issues: social issues, human rights issues, access issues, standard of living, historic issues, and systematic issues. We can go on and on. But really, it was an enlightening discussion today, and thank you so much. And it was a really big privilege to hear from our esteemed speakers and our panelists, whose expertise really illuminated us. A lot of the things we were talking about today are quite complicated and nuanced ideas and principles. International court systems as well are usually have this veil of of ambiguity for a lot of African lawyers, and we hope that this discussion helped to illuminate some of these corners of uncertainty. I'd also really like to express my gratitude to our attentive audience. Your questions and your engagement really shaped today's dialogue and emphasized the importance of collective action when it comes to addressing these climate challenges. So as we continue onwards today, I'd like to give us a challenge to continue advocating for equitable and sustainable solutions. Colleagues, there are 5 other sessions, as I mentioned, that are running currently today that are inspired by all these 3 advisory opinion processes that we've been alluding to. If you want to join any one of those other sessions, please make your way to the World Youth for Climate Justice's website, where you can register and hopefully key into one of the other sessions. But thank you once more from myself and Nicole and all our panelists, and we look forward to our paths hopefully crossing in the future. Take care.
Thank you, Nosaga. Thank you.